Hi friends, welcome to this fortnightly current affairs update. So I am Rangarajan, author of courseware on Polity Simplified. So this book come courseware has online content, and there are a lot of online content, practice test, model answers, additional learning content, and most importantly, there is monthly current affairs updates that go along with this book. So once you buy this book, you can register on the Edge platform, and every month, starting from November 2023 till September 2025, every month monthly current affairs update is there, and it is very important from an examination point of view because a new judgment comes, an amendment happens, important policy, polity related some law comes. Those can also be asked in the exam, but you will have to go in search of some current affairs material for that. If you have any other book, but with courseware on Polity Simplified, you don't have to go anywhere else. I thought I will also, for the benefit of the audience at large, the aspirants at large, make a 15-day every fortnight, and that is my aim, and I hope I stick to it. Monthly current affairs update will be there as part of the Edge platform in the book, in the courseware. But summary key developments every fortnight, I thought I will summarize and provide it in the form of a current affairs capsule. These are purely related to polity and governance, right? So I always have this format. Supreme Court judgments or observations is one section, and any other developments in terms of legislation or election commission action or some law or amendment, that is in the second section, right? So first, a very important judgment of the Supreme Court. Well, there are critical analysis of this judgment. Some people say that it is not completely in sync with the constitutional provisions, but the Supreme Court has said, see, who can become district judges? The Constitution Article 233 says, the posting and promotion of district judges shall be decided by the governor in consultation with the High Court having jurisdiction over that state. And this first clause of Article 233 used to be the process by which judicial officers with whatever years of experience as may be from state to state are promoted to the post of district judge. And this usually consists of 50% of the vacancies are filled through this process. The second clause of Article 233.2, or Article 233, that is 233.2, says that anyone who is not in the service of the center or state government and who has been an advocate for 7 years will be eligible for appointment as a district judge. This was what was known as direct recruitment from advocates. And this required 7 years experience as an advocate. And this used to constitute usually 25% of the appointments. And then judicial officers can also take part in the departmental competitive exams, and 25% used to be filled like that for district judges. Now, there are some people who have been advocate for a few years and then got into some judicial office. It could be a second-class magistrate or some such post which will qualify as a judicial office. Now, the Supreme Court in a 5-judge bench has recently interpreted that if you are an advocate and if you have held a judicial office combined for 7 years, then also you're eligible for direct recruitment. So, this is the interpretation of the court, right? Some critiques have said that, the first clause is different, second clause is different. The Supreme Court has tried to merge the two. But anyways, this is the interpretation, and it has said 35 years minimum. So this is an important judgment from the qualification for a district judge perspective, which is part of the subordinate judiciary, and we should be aware of it. Surrogacy Regulation Act 2021, its rules were notified in 2022. There is an age limit. The woman has to be between 23 and 50 years, and the male has to be between 26 and 55 years. The Supreme Court has said that if somebody has initiated the surrogacy procedure before the notification of this law, which was in January 2022, then this age restriction shall not apply to them. They can continue with their surrogacy process. So that is an important judgment with respect to the Surrogacy Regulation Act. And guys, if you notice, I also mentioned what is the relevant section of the static portion in the book where this might have been discussed or something related to this might have been discussed. The idea is When you are reading this current affairs update, you make a note of it in that static portion so that you again revise it without fail, right? So this is relating to rights issues of women, of married couple. Then Ladakh and Sikh schedule, it's so much in the news. I've written a full page article in the Hindu also about that, about a few months back. So Sikh schedule status, Ladakh is now a union territory without an assembly. It has an elected Lok Sabha MP, that is the only democratic representation at the parliament level, because there is no state legislature anyways there. There are, of course, hill development councils at Leh and Kargil, which are the two districts, big districts of Ladakh. Sonam Wangchuk and other activists have been demanding sixth schedule status. Some of them have been demanding full statehood. I even had a parley session in the Hindu, which got about last week on this. I think statehood is still quite far away, but sixth schedule status may be considered to give more autonomy. But this brings into focus the fifth and the sixth schedule, which is a favorite topic of UPSC. So we should be aware of it. This is linked to chapter 22, which is the miscellaneous areas of the Constitution in my book. And Sonam Wangchuk has been detained, preventive detention, right? He is the three idiots, was inspired by his story. So everybody got to know. Of course, he was a great educator and activist even before that. But yeah, now this political climate, that's a different issue. But his contribution to children's education and climate change activism is definitely something which is commendable. But yeah, in this process, he has been preventively detained under the National Security Act. That has been in the news. His wife has moved to the Supreme Court saying that the ground should be told to me also. The government has said that no, as per Section 8 of the National Security Act, it is only the detainee who needs to be told about the grounds which you have informed to Mr. Sonam Wangchuk. So this brings National Security Act again in the news. So some key points relating to that law, which can be tested in the prelims. Section 8 of the NSA requires the authority to convey the grounds of detention to the detainee, usually within 5 days, maximum under extraordinary circumstances within 15 days. Of course, they need not disclose if in public interest they don't want to disclose, but otherwise, this is the timeline given for sharing the grounds of detention with the detainee, which is the person who is been detained. Advisory board has to be constituted, that is the protection under Article 22 in fundamental rights. Advisory board has to be constituted within 3 weeks of detention. The advisory board has to complete its work and submit its report to the appropriate government within 7 weeks of detention. And the maximum period for which a person can be detained under the National Security Act, of course, beyond 3 months, if he has to be detained, advisory board has to give a opinion. That is the protection under under Article 22 of the Constitution itself. And that is what NSA also provides. But the maximum period as per the NSA Act is 12 months. So this is the capsule for the fortnight from October 1st to October 15th. I'll see you again in the next capsule for 16th to 31st, somewhere during the first week of November. And the entire monthly current affairs update with my video and the document will be uploaded in the Megra Highlights platform as always, which can be accessed through the book. All the best. Happy Diwali to everyone.